Close to 2 hours. I'm not sure. I didn't check the time. In closed session, discussing the constitutional issues around both Bridget Ann Kelly and William Stepien claiming their right to the Fifth Amendment on the production of documents. Our attorneys supplied the entire committee last week, to Friday, with a complete background on those constitutional issues. We came out and passed motions to, in turn, let both of those folks and their attorneys know that, in fact, we do not believe they have constitutional grounds to stand on the Fifth Amendment for the production of documents before that committee. That's the non-lawyer just explained that. Now I'm going to turn it over to the lawyer who's going to try to make it much more complex for all of you, I'm sure. But in fact, the entire committee participated. I believe every member in there seemed to agree on the idea of the constitutional issues. And I really can't explain the abstentions that you'll have to get from the folks who did them. Thank you. John?
Thank you, Co-Chair. Just so that we're clear, there were three motions for each of the two sets of objections the committee received. One of the objections is that the matters sought were not valid, that they were somehow beyond the committee's scope or beyond the committee's authority. So the first motion was to validate, to say that, in fact, the subject of inquiry was valid and was relevant to the committee's investigation here. That was the first motion. The second motion considered the objections that they had made on constitutional grounds, and the committee rejected those. And the third motion was to authorize counsel to set a date by which they have to comply, and in the failure of that compliance, counsel is authorized to take all appropriate legal steps to enforce the subpoena. So that is the three motions, each for one set for the objections raised by Bridget Kelly's attorney, one for the objection raised by Mr. Stepien's attorney. Any questions? Brian?
Can you please clarify how this authorization for your counsel comports with the earlier action of contempt that the original committee, I guess, found against David Wallace?
This is a process that we've relied upon counsel's advice to follow that will enable the committee to provide the opportunity for those who are objecting one last shot to provide the documents, and in the failure of that, to take appropriate legal steps, which I'm not going to get into and discuss what they may be, to enforce the subpoena. So a variation on what we did last time.
Could it include contempt? Is that an option?
Well, there are lots of options out there, Brian. I don't want to get into the specific legal mechanisms that counsel might be authorized to undertake, other than the counsel's been authorized to take the necessary steps to enforce the committee's subpoena as he sees fit, as the circumstance warrant. The counsel is going to set a new date in talking with the counsel for both parties who have refused to comply with the subpoenas.
There was some talk about 12 more subpoenas were going to be issued today. Was that discussed?
The committee met in executive session and discussed the issuance of additional subpoenas in accordance with the process that we went through last time. Once those subpoenas are served, we'll let you know who those subjects were of the subpoenas, but again, we don't want them to find out on the 6 o'clock news. We want them to find out when they receive the subpoenas.
Last time you gave us a breakdown of individuals and organizations. Can you do something similar along those lines?
I really couldn't. I'd have to go back and look at our notes, but I think it's all individuals.
Are subpoenas being served right now?
I don't have a gross number for you right now. It's probably more than that.
Are there subpoenas being served tonight and tomorrow morning? Is that what you're saying? That they're on their way out?
The co-chair and I have not yet signed the documents. My guess is, given the hour of the day, it is unlikely that they will actually get out of this building before the close of business. So that process will probably start tomorrow.
Is it probably more than what number? I couldn't hear.
Somebody had asked if they're 12. I said, I think it's more than that number, but I couldn't give you an exact count.
It's all individuals.
I'm pretty sure. I don't Don't hold me to that, but I'm pretty sure.
Are you going to be looking at the governor's helicopter rides, any of those trips?
Well, like I said, we're going to wait till all of the documents are served, and then we'll fill you in on the details of who got served for what, but we're certainly not going to announce the service of process today in this press conference.
John?
Yeah, Michael.
When David Wildstein found in contempt, I think you referred that to the Mercer County Prosecutor's Office. Do you know what happened to it? Did it get lost there, or?
I'm sure it didn't get lost there. I'm sure that they are doing their due diligence on what they should be doing with that, and I'd have to refer you to inquire of them exactly what their process will be.
Yes. Has the committee heard anything about Governor Christie's office's internal investigation into this, and has the attorney reached out to you guys at all to make sure they're not, stepping on your toes or anything like that?
We understand that the governor's office is doing an internal review and that there have been interviews and something going on there, but they have not shared any of that data with us.
Do you feel like the U.S. attorney's investigation is impeding your own investigation?
Well, I think these are two separate investigations. I want to be clear, because that keeps coming up. This is a legislative inquiry. Our ultimate goal is to fix clearly a broken organization in the Port Authority. The U.S. attorneys gets involved for entirely different reasons. So there are two parallel objects here which may not interfere with one another. And at this point in time, our counsel is very confident that we can proceed under the path we've been proceeding.
Can you tell us how
Yes,
many,
Angie.
can you update us on the 20 subpoenas that were due to be returned last week? Where do you stand with that, with the extensions and what you've gotten back so far?
The process is unfolding. There were some accommodations made by counsel. For instance, we all know, it's very well publicized, that the gubernatorial campaign is seeking advice from ELEC as to how they can proceed. So obviously there was an extension granted on that. And there are others that were granted. Some are being provided on a rolling basis. And so each day there are more documents, and we're going to continue to review them as they come in and make decisions based on the information we get from those documents.
Can you tell us how many individuals or organizations have submitted? I guess you've already said.
Well, I think I don't want to go to that because since some people are responding on a rolling basis, I don't want to describe somebody as having not responded when in fact they've given us some stuff.
Or somebody who has responded hasn't given us everything.
Senator Weinberg, what did you think of the governor's repetition last week of the line about the 3 lanes being dedicated to Fort Lee when he was on 101.5?
Well, apparently the governor hasn't listened to me over the last 5 months, but there's nothing very unusual about that. In fact, Pat Foy, I believe, testified there are no lanes dedicated to Fort Lee. Anybody who lives in the area knows there are no lanes dedicated to Fort Lee. There are access lanes from local streets that most of us who live in surrounding communities use. And in fact, and I think I'm quoting from Patrick Foy's testimony, the whole story about only 4% of Fort Lee residents have transponders. But in fact, those 3 lanes are 25% of the 12 lanes on the upper level. And Pat Foy himself testified they carry 26% of the traffic going over that bridge. Traffic that comes from surrounding areas, even from Hudson County. They actually travel into Bergen County and pay their $13 and drive over the George Washington Bridge. So that is a myth that should no longer be perpetrated. It is untrue. They don't exist, and everybody should know that by now.
The Mercer County Prosecutor's Office deciding if they do move forward with the contempt charge against David Wildstein, that would certainly seem to provide some teeth to the threat that the committee will take any necessary steps needed to get the information that it needs. Is there lack of movement on that undercutting your effort at all? Would it be perhaps more helpful for you guys if they were to make an example of this situation, so to speak?
I don't think we're going to comment on the actions of the Mercer County Prosecutor's Office other than we're very confident in the process we followed today. We have the utmost confidence in our counsel in the process he's recommended that we follow today. We're going to follow that process. We're very confident that not only do the subpoenas stick within the authority granted to this committee, are seeking relevant information, but also that the challenges they've raised to the subpoenas do not withstand any realistic legal analysis, and so we're very confident in moving forward.
Just to follow on Luke's point, though, is the fact that you don't have any lack of closure or clarity from the prosecutor's office, does that explain why you're taking this more deliberative approach with these?
There is a slight difference. One has to do with Mr. Wildstein's testimony. The issue we're dealing with right now has to do with documents. So I think there's a legal difference between those two.
But it also, I don't think you should read into the fact of the process we're following now and the process we followed under the Assembly Transportation Committee. I don't think there's anything to read into it other than this has become a much more complicated inquiry by this committee, and it is taking a turn that is addressing that complication by following the process we're following now. All I can do is tell you to stay tuned and watch this as it unfolds.
If I may,
yes.
I heard this is a complicated constitutional issue. Are you saying the Fifth Amendment applies to verbal testimony but not to the documents that are heard?
I will tell you this, is that the issue can't be answered in a simple yes or no to your question, other than that to really summarize that the arguments made by counsel on behalf of the two individuals who received subpoenas, while certainly robust, do not pass the scrutiny that's required to look at this issue, that we, based on counsel's advice, feel comfortable that the individuals receiving the document subpoenas have an obligation to provide those documents. I think that broadly you can argue that there's a distinction to be made between oral testimony and documents that have previously been uttered by sending them as an email or a written communication. But I don't think it's the kind of question that is susceptible to a very brief analysis that won't bore everybody else to death here.
Michael, that these are constitutional claims, don't you have to go to the federal court then to get this ultimately resolved? And is there any precedent for legislative committee who do this?
No, constitutional claims are raised all the time in state court, and state courts are appropriately equipped to deal with both federal and state constitutional issues. And this arises, let me finish this arises out of a state legislative committee. And so the forum of choice is going to be New Jersey Superior Court. If it gets to that, and I'm not saying it is, but saying if it gets to court, it would be heard in New Jersey Superior Court. But I think we're not there yet. Like I said, what we've done is we've said that we believe that the scope of inquiry of the committee is valid, number one, that we've reviewed their objections, number two, and found them not to be valid, and number three, we've authorized counsel to set a date by which they have to comply, and then we've authorized counsel to follow all necessary legal actions to enforce the subpoena. I don't want to get into a hypothetical of, well, if we do X and they do Y. Let's let the process play out.
Have you modified the subpoenas at all to Kelly and Stepien?
There was a back and forth between counsel, and there was some modifications on the documents requested and the material requested that we're comfortable with, and we're going to move forward on that basis.
Specifically, there were 8-4 vote, party line votes on this. Are you concerned, given all this discussion that had been made about, the partisan accusations of this being a witch hunt and being partisan imbalanced, that this is going to be a template we're going to see going forward, that the Republicans will pretty much object to any?
Well, I hope not.
Do you have any kind of indication that?
There are no Democratic facts or Republican facts here, just the facts. And what this committee has been charged to do is to look at getting answers to a very simple question at this point in time. Is somebody in the governor's office issued an email, and that email resulted in Fort Lee being gridlocked for 4 days. We don't know why it was sent. We don't know under whose authority. But there are facts out there somewhere that would answer those questions. As I said, those aren't Democratic facts or Republican facts. There's a facts, and we're trying to get to those facts. You'll have to ask the members who abstained as to the exact basis of their abstention, but all of the issues that were covered in those motions were adequately, amply discussed in executive session.
Senator Weinberg,
David Wildstein objected also on the grounds of his Fifth Amendment rights, and that went to court. Is there anything different about the way that Virginia Kelly and Stepien are objecting to these subpoenas that makes their challenge different from Wildstein's and potentially could have a different outcome?
Yeah, again, I'm not the attorney here, and I will defer to my co-chair if he wants to interrupt, but
I'm not going to interrupt. I know better.
Mr. Wildstein's Fifth Amendment, he had supplied documents. His Fifth Amendment objection was on his testimony. This has to do with us subpoenaing documents. We haven't called these people yet. They haven't appeared before us in order to take the Fifth. This has to do with the production of documents. Based upon our counsel's very, very good analysis, there are constitutional grounds here that we feel we're on very solid ground. And I will add that in our closed session, I heard no objections to those constitutional grounds, by the way, from anybody on the committee.
Thank you, everyone. Senator, last week and asked the governor said something about telling his chief of staff and chief counsel to look into this as soon as he heard. And that sounded like new information to me that he hadn't brought up before, that he really did try to investigate this as soon as this happened. Is this new to your ears too and raise other questions for you? Yes.
I'm not going to comment on that.
It's a long smile. Assemblyman?
I think we have to look at where the facts
Yeah.
take us. Things being said, and there are a lot of things being said by a lot of people. And we, at the end of the day, have to take a look at all of them and create some kind of timeline and understand who knew what when. That's ultimately what the inquiry of the committee is. Who knew what when, and who authorized this.
And why.
And why. And so, ladies and gentlemen, thank you. We'll continue to keep you advised.